we don't have an omnibus bill, but what we do have is different states with their own unique ideas of what privacy should look like. One of our favorite ones that's coming up, well, everyone's favorite is obviously CCPA and CPRA, but let's talk about the changes in people are talking about biometric laws, and of that, obviously New York being one of them. Could you talk a little bit about this new swing of interest in biometric laws, and what does that mean? What states generally are implicated, and how does that play itself out?
Yeah, so you sort of highlighted something that's the uniqueness of US law, which is that we're very willing to sort of look at privacy in discrete industries or with discrete sets of types of data. When we start talking about sort of a general privacy law, we've sort of been very skittish about that. Part of that is because unlike the EU, we don't really have this foundational concept of privacy. You know, we have the Fourth Amendment, which really deals with privacy vis-a-vis the government. And frankly, we've had a privacy bill the Privacy Act of 1974 that restricts government collection of our information, which if you look at it, very, very similar to the GDPR. So I just want to point that out. In 74, we were sort of on this path. But when it comes to private sector collection of data, that's where we're a bit more skittish in the United States. So what we're seeing is states, like you said, sort of tackle this in different ways. We have the CCPA approach, which is one that's sort of being adopted by a number of states. I think Virginia, Oklahoma, Florida are the current ones that are like in everybody's inbox this week. But then we have a lot of states that are saying, you know, we're not necessarily going to get the buy-in for a general privacy law, but we can all agree that there are certain sensitive data out there that we need to protect, right? This is like the healthcare argument. Like nobody really fights healthcare privacy. We have to figure out how to deal with HIPAA. And so one of those is biometrics. And the reason being that, you know, biometrics tend to be inherent to who you are. Last time I checked, you can't get a new face. So if you're using my face to gain access into systems, that's going to be a problem if you steal my facial recognition, right? That's going to be an issue. So we sort of have this buy-in in a number of states saying we feel very confident that biometrics is something that we should regulate. Now, Illinois has led the charge in the United States and is a very aggressive enforcer of its Biometric Information Privacy Act, or BIPA. We've actually seen a number of lawsuits get filed that have some very, very high settlement amounts or fines or damages that come out of it. You know, I think in general, we have this consensus that's using biometrics without consent, using biometrics in a way that we wouldn't necessarily have anticipated is very damaging to the individual. Because again, I can't go out and get a new face like I could get a new social security number or, you know, other identifiers that might be easily changeable. So Illinois has really set the scene for biometrics, but then we have states like New York that have recently put forth biometric data privacy laws, very analogous to the Illinois. And what they often require is things like consents, deletion of the data after a period of time, being transparent as to how you're processing that data, if you're using third parties, how those third parties are gaining access to that information. And what's a little bit different about the New York law is that it has heightened fines per violation. So it's really upping the ante for companies when it comes to biometrics. And for most companies, biometrics are really going to come into play with employees. So we see this more and more, using a thumbprint to scan into a building, using an eye scanner, using facial recognition technology to get into systems that we find are really sensitive, or sort of this cool technology that we want to use. And that's what we're seeing in Illinois, is that a lot of the lawsuits, it's not necessarily consumer driven, it's driven by your employees. And guess what? They have a private right of action. So I can bring a lawsuit quite easily in those jurisdictions because I can basically claim, you know, a BIPA private right of action. I'm going to get past a motion to dismiss, and then we're going to go into a full-blown lawsuit. So we anticipate sort of that same trajectory within New York. Once that law is passed, there are going to be proactive requirements on businesses if they're collecting biometrics. And I would highlight too, so many businesses will say, I don't collect biometrics. And then I'll look into it and I'll say, okay, do you use a third-party vendor to collect it? And they'll say, oh yeah, of course I use a third-party vendor. Well, guess what? That's you collecting it, because you're going to have obligations and responsibilities for any third party that you bring into sort of this data transaction. So it's really important that you sort of really sit down with your team and say, are we collecting biometrics? Is that from employees? Are we collecting them from consumers? Are we doing anything funky or weird with those biometrics? You know, it's really important to stay on top of that. And I'll add one point to this because we are seeing this mostly at the state level, but the FTC, the Federal Trade Commission, which does a lot of privacy and security enforcement at the United States, across the U.S. at the federal level, they just had a case where they had a consent decree against EverAlbum, which is it was a platform that collected photographs. And it's an interesting case. It's talking about facial recognition technology. And in essence, there wasn't the appropriate consent and the privacy policy wasn't clear enough, et cetera. So if you're doing anything in facial recognition technology, you've got to take a look at that case, because that's going to tell you what the FTC thinks needs to be in those privacy policies. But what was really interesting about that case, and I think is actually the more impactful part of that case, is that they required that EverAlbum not only delete the data that they had collected, but delete the models they had built off of that data. That is literally deleting your business assets, because the models are what is valuable. Like, yes, your face is valuable to train the model, but once I've trained it, your face is no longer valuable to me, right? I'm deleting that data is like, okay, that's fine. But because they built it off of data that they never should have had access to or didn't appropriately obtain access to it, they made them delete those models. And that is a business asset, that's IP. There's a lot of consequences for a business. So it's really important that you get the appropriate consents, acknowledgements, et cetera, from the start. Because if not, everything that comes from that might end up being an asset that has to be destroyed.